Good afternoon, everyone. I am Michael Hayden, president of the Massachusetts Bar Association and a partner at the law firm of Morrison Mahoney. It is my pleasure to welcome you to the 2025 State of the Judiciary Address. The MBA is proud to present this event each year in collaboration with the Supreme Judicial Court. Thank you to all of our judges and court personnel in attendance, and thank you as well to everyone working behind the scenes to ensure this program can be hosted live in the 7 Justices courtroom here at the Adams Courthouse, and also broadcast live to all of our viewers online. Soon you'll hear this year's State of the Judiciary from SJC Chief Justice Kimberly Budd. Following the Chief Justice's remarks, I will moderate a panel discussion with Chief Justice Budd and Trial Court Administrator Thomas Ambrosino. While originally scheduled to participate in the panel discussion, Trial Court Chief Justice Heidi Brieger had to travel out of state for a significant family event and is unable to join us this afternoon. We send her and her family our best wishes. On a serious note, judges have long dealt with the burden of decision-making, whether the weight of sentencing a defendant to incarceration or the stress of deciding a complex family court matter. Feelings of isolation are commonly reported when judges lose the camaraderie with members of the bar that they enjoyed during their careers as litigators. More than ever before, the judiciary needs our support. The recent trend of unprovoked and deeply disturbing attacks upon judges and their families has shaken the judiciary to its core. The murder of U.S. District Court Judge Salas's son, Daniel Anderl, on the doorstep of her home is a senseless tragedy that no jurist should ever have to experience. Closer to home, our judges in Massachusetts have been increasingly harassed with heightened public criticism, doxing events, and even pizzas delivered to judges' homes and to their family members. Last year, security stopped an individual who attempted to storm through the doors of the Woburn District Court. Quite simply, the time for decisive action to protect our judiciary is now. The federal Daniel Anderl Judicial Security and Privacy Act provides some protection for the personal identifying information of our judges, but only in the federal court. It does not extend any protection to Massachusetts state court judges. The Massachusetts legislature has taken up this initiative and drafted 2 bills, Senate Bill 1278 and House Bill 1766, which would establish the Massachusetts Judicial Security Act, protecting the confidentiality of personal identifying information for all judges in Massachusetts in both the state and federal judiciary. Last month, I testified before the Judiciary Committee at the State House, voicing the MBA's full support of the proposed Judicial Security Act and the urgency that the current landscape demands. The legislature's Judicial Committee is accepting written testimony until next month, and I encourage anyone and everyone interested in supporting the Judicial Security Act to write to your local congressperson or send your testimony to me, and I'll make sure that the MBA puts it in front of the Judiciary Committee for its consideration. On April 22nd through April 24th of next year, the MBA is co-sponsoring an ABA litigation section annual conference being held right here in our backyard at the Hilton Boston Park Plaza, where U.S. District Court Judge Salas will serve as a featured plenary speaker, leading a conversation on judicial independence as a cornerstone of advancing the rule of law. These are not new concepts in the Commonwealth, as demonstrated by the separation of powers language that John Adams wrote into Article 30 of our Massachusetts Declaration of Rights back in 1780. Adams concluded Article 30 by stating, "To the end, it may be a government of laws and not of men." 245 years later, we still continue to advocate for the rule of law. And those of us who utilize and work in the courts of our Commonwealth are fortunate to have judicial leaders who are both brilliant jurists and also remain accessible to and collaborating with the MBA. As the leader of our court system, Chief Justice Kimberly Budd has exemplified this collaborative approach with her steadfast leadership and unwavering commitment to the administration of justice. 5 years ago this month, Chief Justice Budd made history when she became the 38th Chief Justice, first Black woman Chief Justice, and the youngest person in Massachusetts in over 150 years to be sworn in as the Chief Justice of the Massachusetts Supreme Judicial Court. A trailblazer throughout her professional career, Chief Justice Budd first ascended to the bench after being appointed to the Superior Court by Governor Deval Patrick in 2009. She served as the Regional Administrative Justice for Middlesex Criminal Business in 2016 before being elevated to the SJC that same year by Governor Baker. A graduate of Georgetown University and Harvard Law School, Chief Justice Budd has taught trial advocacy at Harvard and formerly taught as an adjunct at New England Law at Boston. Chief Justice Budd is one of our Commonwealth's most important leaders. She is a staunch advocate for access to justice and restorative justice, and I have personally witnessed Chief Justice Budd's commitment to Massachusetts attorneys, whether administering my own oath of office back in September or traveling to Portsmouth, New Hampshire to sit on a panel of all 6 New England State Chief Justices at the New England Bar Association annual conference recently, or most recently presiding over the swearing-in ceremony for newly admitted Massachusetts attorneys at Faneuil Hall. While her responsibilities at the SJC would more than justify remaining in chambers to work through an immense docket, Chief Justice Budd consistently and reliably makes herself available, and in so doing elevates the significance of each event she attends and makes each event more meaningful for those attendees fortunate enough to hear her speak. It is now my distinct honor and privilege to welcome Supreme Judicial Court Chief Justice Kimberly Budd for the presentation of her State of the Judiciary remarks.
Thank you, President Hayden, for those very, very kind words. And thank you to the Massachusetts Bar Association for sponsoring this program today. I also want to welcome our other guests from the MBA, including President-elect Sam Siegel, Vice President Shayla Mumbler, Treasurer Mark Mochia, Secretary Sabrina Bonanno, Chief Legal Counsel and Chief Operating Officer Marty Healy, and Director of Policy and Operations Lee Constantine. The MBA and other bar associations are so important to the health of our legal system. By providing education, mentoring, and fellowship for your members, supporting pro bono service, legal aid, and programs like the Judicial Youth Corps, and advocating for the needs of the courts, you help strengthen our system in so many ways. And in this challenging fiscal year, I particularly appreciate MBA's strong support for the court's budget requests. Speaking of court funding, I'd also like to take this opportunity to thank our legislative leaders for their efforts on behalf of the judiciary, including House Speaker Ron Mariano and Senate President Karen Spilka, the Ways and Means Committee co-chairs, Representative Aaron Mickelwitz and Senator Michael Rodrigues, and the Judiciary Committee co-chairs, Representative Mike Day and Senator Lydia Edwards. I also want to thank my colleagues in the Judiciary for the dedication and commitment that they show every day, whether it's on the bench or writing decisions or in handling administrative tasks. And many of them are here today, including colleagues from the SJC, the Appeals Court, and Trial Court, judges, clerks, deputy court administrators, and many other members of our court family. Finally, I want to especially recognize Trial Court Chief Justice Heidi Brieger and Court Administrator Tom Ambrosino. With 94 courthouses, hundreds of judges, and well over 6,000 employees, the trial court is a sprawling enterprise to manage, and they do so with skill and aplomb. I also want to congratulate Chief Justice Brieger for taking on a responsibility that rivals being Chief Justice of the trial court, and that's serving as grandmother to 2 new grandchildren, twins Lydia and Phoebe. Although she's not here with us physically, she's with us in spirit, and she said she'd be tuning in. We do have Court Administrator Tom Ambrosino here in person, and I look forward to sitting down with him and President Hayden to discuss the issues of the day. Whether you work inside or outside the judiciary, your efforts in support of the courts are especially important now, because at times like these, when there seems to be increasing discord and strife in our society, the courts can help maintain stability and order by resolving disagreements fairly and rationally and according to the rule of law. Judges are human, and we certainly make mistakes. But in reaching decisions, we strive to respect the principles established in our state and federal constitutions, to faithfully interpret the statutes enacted by the legislature, and to follow the guidance embodied in past court decisions. We endeavor to base our rulings not on personal preferences or political predilections, but on the fundamental tenets by which our democratic society has agreed to govern itself. In the words of the Massachusetts Constitution, and as you just heard President Hayden say, we seek to promote a government of laws and not of men. That phrase appears in Article 30 of the Declaration of Rights, which guarantees the separation of powers between the executive, the legislative, and judicial branches. And as judges, we are particularly fortunate here in Massachusetts to be working in a governmental system that clearly supports judicial independence, and where judges are appointed rather than being elected. To be worthy of such independence, however, our courts must maintain the people's trust and confidence by demonstrating that they are both accountable and accessible to the public. And that's why many of the initiatives that we are currently undertaking are targeted at making the courts more transparent and easier to use. For example, last February, the SJC updated judicial guidelines for civil cases with self-represented litigants. These new guidelines detail the types of steps that judges can take without violating their obligations of impartiality to ensure that many litigants who appear in our courts without counsel are fairly heard. The new guidelines encourage judges and court staff to explain court procedures to self-represented litigants and to refer them to resources where they can get help, such as court service centers, lawyer for the day programs, or legal service organizations. The new guidelines make it clear that while the law still applies to all litigants, regardless of whether they're represented by counsel, that doesn't prevent judges from adjusting procedures or technical requirements for self-represented litigants, as long as the opposing party's right to have the case fairly heard isn't prejudiced. We've also been working to harness technology to help people navigate courthouses and court procedures more easily. For example, we've completed Wi-Fi upgrades in nearly all of our courthouses, improving access to online resources for court users. And last year, we launched a digital signage pilot program in Chelsea District Court that we hope to expand in the future, subject to available financing. As a part of the Affordable Homes Act, enacted in 2024, the legislature authorized procedures for sealing eviction records so that tenants are not perpetually stigmatized by past proceedings. In May, the Housing Court, District Court, and Boston Municipal Court collaborated with the Suffolk University Law School's Legal Innovation and Technology Lab to develop an online program to implement the new law. This program enables tenants to create and file petitions to seal records of past eviction cases simply by answering a series of questions on a computer. In doing so, tenants can prepare and file a petition to seal past eviction records online. The program has proven to be incredibly popular. Since it was launched, it's been used to prepare and file over 1,000 eviction sealing petitions in the Housing Court. And these are just a few of the examples of the ways in which technology can make our courts easier to use, and will continue to pursue additional innovations. Now, discussions about technology these days invariably lead to the topic of generative artificial intelligence, or Gen AI. My colleagues on the SJC and I recognize that Gen AI offers enormous potential for streamlining many aspects of the work of attorneys and courts alike. At the same time, we also recognize that the use of Gen AI raises concerns, especially at this relatively early stage in its development. There's specific questions around reliability, confidentiality, and cost, to name just a few. On a more fundamental level, we must ensure that Gen AI does not adversely impact judicial independence and undermine public confidence in the administration of justice. For these reasons, we are committed to being curious and open-minded about Gen AI, while simultaneously being deliberative and thoughtful in how and when we use it. Let me outline just a few steps that the court has already taken when it comes to this new technology. As you all are no doubt aware, there's been quite a bit of attention devoted to how attorneys can integrate Gen AI into their practices while not running afoul of their ethical obligations. Naturally, this led to a question of whether additions or modifications to the Massachusetts Rules of Professional Conduct were needed to address the use of Gen AI in the practice of law. So, we asked the court's Standing Advisory Committee on the Rules of Professional Conduct to take a look. They did so, and ultimately they have not recommended any changes. They found that the existing rules and comments provide ample guidance for attorneys at this time. The committee further noted, however, that their recommendation may change as this new technology continues to evolve. Recently, the SJC also issued interim guidelines for the use of Gen AI by judges and other court personnel. Only public information can be used, and the tools must be disabled from retaining any information or using any of it to train the AI programs themselves. We recognize that these guidelines are a modest first step, but we believe that they're necessary and appropriate for the reasons that I first mentioned. Keeping in mind that they're interim guidelines, we expect to update them as we learn more. Finally, we recognize that Gen AI also has the potential to facilitate access to justice for people who cannot afford lawyers. And with that in mind, the Access to Justice Commission is studying potential ways to harness these tools to increase access to justice while minimizing the disparities caused by cost. We look forward to their findings. Whatever improvements new technologies, including artificial intelligence, may bring, I want to stress that our legal system is and will remain centered on human intelligence, understanding, and judgment. It ultimately depends on the people who work within the system, whether they're the judges, clerks, court officers, probation officers, and other staff who work for the courts, or the lawyers who advocate on behalf of their clients, or the jurors who render verdicts. And as we go about our daily business in the courts, it's important to keep in mind our common humanity. I know that the adversarial nature of litigation may cause tempers to flare, but let's remember and appreciate everyone's contribution to our joint enterprise of doing justice. Whatever may be going on outside the courthouse doors, we can at least strive to make our courts places where we value one another and treat everyone with dignity and respect. And that's one more way in which we can help to promote stability and order in our society. Thank you.
Thank you so much, Chief Justice Budd. Now I'd like to invite Court Administrator Tom Ambrosino to join Chief Justice Budd and a panel discussion about what our courts are doing and what's coming up next for our judicial leaders. For the format of the discussion, we will all remain seated, and I'll present questions to both the Chief Justice and Mr. Ambrosino. By way of background, Thomas Ambrosino has been the court administrator of the trial court since January of 2023. Together with trial court Chief Justice Heidi Brieger, who is the policy and judicial head of the trial court, Mr. Ambrosino helps oversee more than 6,000 court staff in the 94 courthouses across the Commonwealth. Mr. Ambrosino is responsible for all of the trial court's administrative functions, including budget preparation and oversight, labor relations, information technology, capital projects, and personnel policy. Mr. Ambrosino previously served as city manager in Chelsea and was formerly mayor of Revere for more than 10 years. Many of us know him from his previous role as executive director of the SJC at the time when the trial court administrator role was initially created. He is extremely well-versed in the needs of the court and, like his colleagues, is also known as an effective collaborator. The MBA is very grateful to Mr. Ambrosino's commitment to collaboration, as he has regularly appeared as a guest speaker at the MBA's House of Delegates meetings to keep our members apprised of recent developments and pressing concerns in the court. Welcome, Mr. Ambrosino. Our first question is for Mr. Ambrosino. With the current budget constraints placed on the courts during this fiscal year, what impact will the lack of full funding place upon the trial court?
So I think the impact is, we're seeing it now, and it's really the lack of personnel within our trial courts. So we are down over 200 employees from where we were just in June of last year. And just to put some context to that, when we started this fiscal year in July, we were looking at a budget of $961.3 million for the trial court. At the time, that was $24 million less than what we needed to continue our operations from 25 into 26. Our budget request to the legislature last year to just maintain operations was $985 million. So at 961, we were looking at a $24 million deficit. The only way an organization, a public organization, can shed that kind of money is through payroll. That's really, most of our costs are non-discretionary. Payroll is the majority of our costs. So the only way to reduce money of that magnitude is to reduce payroll. Thankfully, we were able to do it without involuntary layoffs. We did it with two measures. One was an immediate hiring freeze that we put on in the end of June. By attrition, we typically lose about 30 to 35 employees a month. So the mere fact of a hiring freeze meant that we would start reducing our numbers considerably. In addition to that, because we were concerned the hiring freeze alone wouldn't generate enough savings, we also instituted this past summer basically a retirement incentive program to see if we could entice folks towards the end of their career to advance their retirement, to shed even more payroll. We got a lot of individuals to take advantage of that, over 100. And so we now are 200 employees plus less than where we were in June. Now, that has a real impact on operations. It means that some clerk's offices may be short 5 or 6 individuals. And that may not sound like a lot, but it really means that the work in that clerk's office slows down considerably. It means the phone rings longer than it should and sometimes can't even be reached. It means people in line wait longer. It means attorneys looking for paperwork to be processed are waiting longer than they should. It really has impacted our customer service, and we really were taking great pride in great customer service over the last few years, and unfortunately, that is suffering from the lack of personnel that we currently have. So that's where the impact of the budget cut has hurt us the most.
Thank you, Tom. A follow-up question for you. The legislature recently restored roughly $9.5 million in funding to the courts from the cuts that the governor had made to this year's fiscal budget. Does this increase allow the courts to grow in terms of some of the new initiatives that it has in mind for this year and beyond?
So let me say we were very grateful to the legislature for overriding the governor's veto of what was $9.3 million. That override brought our budget back to $970, and it meant that what it means is that we can start selectively backfilling some of these 200 plus positions that are currently vacant. And we have started to do that. In the last couple of weeks, I've authorized 72 backfills. Now, that's not going to get us back to where we were or really where we need to be, but at least it gives us that ability to address where the needs are most significant. And so we've started to do that. At this point, I will tell you that we're probably pausing on any further backfills and are waiting to see what our number for fiscal year 27 will look like in the governor's proposed budget. And that won't come out until the third Wednesday in January. So we're sort of following that backfill of the 72, we're kind of in a wait and see attitude because whether we can do additional backfilling really will depend upon what our outlook looks like for fiscal year 27. And I say that because we have significant additional monetary needs in fiscal year 27 that are likewise sort of non-discretionary. So our budget request to the legislature for next fiscal year 27, is going to be $41 million more than what we're operating on right now. And it's all non-discretionary items. So 25 million of that are cost of living increases for our union employees. Those are mandated by 3-year collective bargaining agreements, and next year is the last of that agreement. It's a basically 4% increase over the course of the year. That's very expensive to a trial court that has an overwhelming majority of union employees. About 80% of our employees are unionized. So that's 25 million right there. That is non-discretionary. In addition to that, we have sort of non-discretionary lease cost increases next year and utility cost increases. I've said before, people are surprised to know how many buildings we lease as a trial court. Over 50 of our buildings are leased buildings, many from counties, some from municipalities, some from private landlords. Those lease costs go up every year, as others do. In addition, next year we have 2 big leases kicking in that are necessary to accommodate new court buildings we are building. So we're building a new Quincy Regional Justice Center, and we need a temporary location for the folks in Quincy. That will start next year. That temporary leased facility, just that one alone, is going to cost the trial court over $6 million annually. We have a similar situation in Lynn, where we're renovating the Lynn District Court. Again, we need a temporary location for those employees. That's another $2.5 million. So we have these big lease expenses that are adding up to another $11 million. Again, sort of non-discretionary, not much we can do about that. And then over and above that, we have IT operating costs that are going up. This isn't modernization. This is just additional operating costs because we have modernized over the last few years our operating costs, our software licenses, et cetera. Just one example, which you could understand, the chief mentioned we put Wi-Fi in all of our buildings, very robust Wi-Fi that we didn't have before. Well, our Wi-Fi providers charge us a lot more for that than they used to the tune of about $1.2 million more than we were paying last year. So all of these non-discretionary costs have put us in a position where our ask to the legislature next year is a significant one. We will, for the first time, be seeking a budget over $1 billion for the trial court. And so we're paying attention to what the governor's number is going to be. I don't want to continue to add additional employees if it looks like we're going to get a number that can't support those employees. I certainly don't want to be in a position where I'm adding employees and then trying to, involuntarily remove them in a few months. So we're paying very close attention to our budget outlook for fiscal year 27, and certainly we'll be hoping that the MBA will be as generous in their advocacy to us as they were in FY 26.
Of course. Thank you so much, Tom. Chief Justice Budd, I always enjoy when you relate the challenges we face today to those that the founders of our Constitution and Commonwealth faced in the late 1700s. You quoted Alexander Hamilton last year during the State of the Judiciary address. In the Federalist Papers, he noted the judiciary lacks the power of the sword and the purse, and you observed that the judiciary's only power is that given by others who respect the court's decisions. Can you give us an example of what the courts are doing today to increase that confidence in our court system here in the Commonwealth?
Sure. The way I see it, there are two components to maintaining public confidence in the courts. One is accessibility, and I talked a little bit about some of the things that the court's doing to make sure that it's accessible to all court users, and especially those who don't have counsel. But the other thing that we want to make sure is that we are accountable and that we are soliciting feedback and making changes where we can do things better. And there are a couple different ways that we do that and have done that in the past. The trial court has periodically sent out access and fairness surveys for court users to respond and tell us what their experience of the courts has been, whether they're able to get the help that they need, whether they're able to find what they're looking for, and how they've been treated. The other thing we've done is relaunch the judicial evaluation process. As you know, it's statutorily mandated that our judges are evaluated, and we started that back up since COVID, since the suspension during COVID, and it gives attorneys, jurors, and court staff an opportunity to let us know how our judges are doing. So far, I think since the program was launched last year, we've had about 100 judges who've received reports based on the evaluations that came back. They have an opportunity to review them with their chiefs of their trial courts, and they're great when they are positive, constructive feedback. Lastly, the appellate courts have had in recent years, have had two bench bar conferences where we have both the SJC and the appeals court has invited those who use the appellate courts in to have a back and forth about the processes and procedures and how things work for them. And we have gathered all the feedback and really taken and been able to respond to the court users to tell them why we do things the way we do, and to consider some of the changes that they'd like to see us make. So we're constantly looking for ways to improve. We're not staying static.
Thank you, Chief Justice Budd. I can certainly report from the MBA's members' perspective, the opportunity for bench bar conferences and collaborations is among the most important benefits that our MBA members receive. So thank you for encouraging that throughout the court system. Mr. Ambrosino, with a tax on the judiciary at an all-time high nationwide, the impacts of which weigh upon not only the mental health and well-being of our judges, but also our clerks and court officers and court staff, what measures are being taken administratively to ensure their safety?
So, the safety of our judges and our clerks and really all of our staff is of utmost concern to us. I mean, one of the best ways we can improve upon safety is to better secure our 94 courthouses. And so part of our bond bill with the legislature was a commitment to upgrade the physical security of all of our courthouses through technology, things like cameras and duress alarms and keyless entry. And so with our capital funds generated from the bond bill, we have started that process of doing significant physical security upgrades in each of our courthouses. Thus far, we have done 21 of the courthouses. We have another 4 of them scheduled for this year. That's a little less than we've been able to do in the past, but that's only because our allocation of capital funds in fiscal year 26 is somewhat less than it was in the past. I'm grateful to A&F. They did at the last minute come up with an additional $6 million in capital funds for us, specifically to do physical security upgrades in these courthouses that we're planning to do this year. So that's really the best way we can protect judges, clerks, staff, litigants, visitors to our courthouse, to make sure our courthouses are secure. In addition to that, you did mention the Judicial Security Act that we are also advocating with the legislature that will help protect and eliminate personal identifiable information on the internet, both for judges and for other magistrates. We also, this past year, implemented a software solution for our judges at the moment, which is Delete Me. It is a product that helps to scrub the internet of personal identifying information. Some judges have found that helpful as well. So we are taking the best steps that we can. Obviously, when there is any kind of incident or any kind of threat, we respond aggressively to that. Our security department works very closely with the state police to ensure that anyone who is the subject of such a threat has adequate protection.
Thank you, Tom. A different question for you, Mr. Ambrosino. Now that we're 5 years after the height of the COVID pandemic and the disruption that it caused to the court system, are current operations back on track? Are there still any backlogs that the courts are grappling with? And what efforts are underway to ensure that the timely resolution of cases remains possible?
Yes, so Chief Justice Breyer and I were looking at this not too long ago. I would say that the COVID backlog is done. Pretty much our filings are back to where they were pre-COVID. In fact, our filing numbers for fiscal year 25 are higher than they were in fiscal year 19, the last full fiscal year before the pandemic. So we're past the COVID impact at that point. Our clearance rate remains very high at over 97%. So I think we are doing a good job of avoiding any future backlog at the moment. I know for Chief Justice Breger, it is a high priority to ensure that cases are disposed of timely. I know she impresses upon all of her chief justices the message to ensure that their judges are paying very close attention to case clearance and backlog, being very diligent about granting continuances, making sure they're only done in the most necessary circumstances. She's also worked very hard with the juvenile court and the probate and family court to implement consecutive trial dates in an effort to ensure that trials are conducted more expeditiously in those two courts through a combination of new rules and standing orders. So this is a high priority for Chief Justice Breger. It's a high priority for me. We are past the backlog. Our goal is to avoid a future backlog.
Thank you, Tom. Chief Justice Budd, are there any pandemic-related effects or initiatives that led to lasting efficiencies across the court system in the Commonwealth?
Well, certainly one thing that we all learned is that not everything has to be taken care of in person. So things that we had to do, turns out they aren't bad ideas to continue. And just to give you a couple of examples, we've expanded the range of information and assistance that people can get online. So that includes information on the courts, on our court web pages. More forms are available online for people to access, and people can get help remotely by way of the virtual court services, court service centers, as well as the trial court law libraries are many of their features are available online. We also have the probate and family courts virtual registries, and Middlesex Superior Court has a virtual help desk. As for remote hearings, that's something that I'm not sure that we would have ever done had it not been for COVID, but as it turns out, there are a lot of hearings that can be done very appropriately virtually, and every trial court has a standing court rule that talks about when and what types of hearings can be done virtually at the judge's discretion, but we all know that it's something that obviously can save lawyers time and their clients money, and so that's something that we're very much encouraging. Additionally, some of the emergency rules that we had during COVID have been made permanent in the Massachusetts Rules of Civil Procedure, including allowing for service by email, allowing depositions by video conferencing, and authorizing the use of electronic signatures by judges and clerks. And I think the Standing Advisory Committee on the Rules of Civil Procedure is looking at electronic signatures for litigants and attorneys at this point. So we're moving straight into the 21st century.
Thank you very much, Chief Justice Budd. Mr. Ambrosino, are there any upcoming IT initiatives designed to support attorneys in their interactions with the courts? You described earlier the progress we've made with Wi-Fi, if not the elevated cost that comes along with it. Could you comment also upon digital signage initiatives that are being rolled out into the courthouses, and talk about what improvements the court has in mind that will help attorneys to better manage their caseloads and case scheduling?
Yeah, I think I can say honestly that all of our IT modernization initiatives are aimed at making the experience of attorneys and self-represented litigants better, making it more efficient for them to operate with the trial court. So you mentioned Wi-Fi, the chief and I mentioned Wi-Fi. I mean, that has made the lives of attorneys and litigants and jurors much better. I mean, 2 years ago, attorneys waiting between cases really couldn't do much work in our courthouses because there was no Wi-Fi. Now, in all but 2 of our courthouses, unfortunately, one is this one and one is the high-rise next door, we have robust Wi-Fi. So that has made the job of attorneys better. You mentioned digital signage. You know, even for attorneys, it helps to know how to access our locations. And so we're very excited about that digital signage initiative. As the chief said, we started that pilot in Chelsea. It's really anyone who wants to see what it will look like when we expand to other courts can take a look at Chelsea. I think everyone's found that well received. Unfortunately, that has been a victim of budget cuts, so we've had to put a halt on further digital signage, at least for this fiscal year. Hopefully we can restart that in ensuing fiscal years. You know, the improvements to our mass court system that have been underway and implementation of a document management system, which is now starting in the court system as part of our IT modernization. All of that is to make the processing of cases better so that the experience of attorneys will be better. And, you know, we've really upgraded our system to handle more electronic filing from attorneys. I was looking at numbers earlier this week, and I think we were receiving about 500,000 documents in e-filing in fiscal year '23. Now we're doing about 2 million a year. So the volume of e-filing has certainly increased, which redounds to the benefit of attorneys. I'd say the last thing, sort of something to look forward to, it is part of our IT modernization, but it is kind of at the tail end of our program, our courtroom upgrades. We are going to upgrade the technology in each of our courtrooms in all 94 courthouses so that it will make it easier, particularly for trial attorneys, to do business in our courts. And if you ever want a glimpse of that future, you can go over to the business litigation section in the high-rise, where I know Chief Justice Ricciuti will be happy to show you what the business litigation session looks like and the high-tech technology that exists in there. So that's sort of a glimpse. That's the template for what we hope all of our courtrooms will be like. When we get to that point, we will truly be a digital court system. And I think the experience of attorneys in the Commonwealth will be much improved.
Thank you, Tom. One of the collateral consequences of Chief Justice Brieger's amazing news of welcoming twin identical granddaughters is that her time allocated to this program was sort of taken up with Chief Justice Budd's remarks and Court Administrator Ambrosino's remarks. So we're running ahead of schedule. I want to thank Court Administrator Ambrosino for fielding the questions that were originally designated for Chief Justice Brieger. Thank you for your time and preparation to provide so much substance to our audience. Thank you always to Chief Justice Budd for your presentation of the State of the Judiciary address and for also participating in our panel. We always welcome your remarks and are grateful for your time and effort to prepare. To all of our friends and family in the audience, it's so nice to see you all in person. Thank you for making the effort to be here. The bench bar collaboration that the MBA prioritizes is something that is deeply meaningful to our members, and it only works when everybody shows up to participate. So please don't take for granted the fact that the MBA puts this on each year. It is a priority that we will continue to emphasize, and we certainly welcome our continued collaboration between the court and the members of the MBA. To those of you watching at home, thank you for joining us. Best wishes for a safe and happy holiday season to all of you, and that concludes our program.